Okay, so we are honored to have Professor Ryan Abbott today. He's a leading scholar and researcher on the topic of AI invention. He is a professor of law and health sciences at the University of Surrey School of Law, assistant professor of medicine at UCLA, a partner at Brown, Neary, Smith & Cohn LLP, and a mediator and arbitrator with IACT. He has worked as an expert for European Commission, World Health Organization, and World Intellectual Property Organization. Managing Intellectual Property magazine named him as one of the 50 most influential people in intellectual property in 2019 and 2021. He has worked as a legal counsel on patent applications whose named inventor was a robot, Davis. Let's learn from Professor Abbott about patent law, his recent research, and recommendations. During this webinar, participants can ask him questions in English. Professor Abbott plans to answer questions after his talk. Professor Abbott, thank you so much for joining us.
Well, thank you. It is a great honor being here today, and I look forward to discussing this very interesting topic with all of you. Before moving on to patents, I thought it might be interesting to talk about some other intellectual property rights that are relevant to machines, namely copyright. And this is a magazine cover in the United States that says it was designed by an artificial intelligence in 20 seconds. And this is a popular magazine that is sold throughout the country. And interesting because machines have been making images from text for a very long time. And academically, it has been of interest to people for a very long time. But only really very recently has AI gotten good enough at doing this that it has started to have important commercial implications. So in the US, we have many now and globally text-to-image generators like DALL-E 2, where you can put a sentence or a few words in and it will make an image that may be an image like this. And these are images that have commercial value. And the implications of this are really quite significant in terms of how people will work with AI to be creative and whether AI will automate creativity and what this will do for people who have a job of making creative things. It also raises all sorts of interesting issues related to intellectual property, because in some jurisdictions, like the United States, you cannot copyright an image made by a machine. In other jurisdictions, like the United Kingdom, you can copyright an image made by a machine. And that is particularly interesting given the global nature of intellectual property. You can have a machine make an image in the US that gets protected in England, but not in America. And as machines continue to do this, they will only get better at making images in ways that are really very disruptive to human creatives and creative industries. But it is not just machines being creative. Machines are doing some of the things that we associate with invention. So this is an image from a video made by a team at Google. And this researcher here is describing work that she and her team did with an AI that used deep reinforcement learning, which is a way to structure an artificial intelligence. They developed an AI that could automate chip floor planning. And chip floor planning is when you arrange the components on a microchip. And the manner in which you arrange those components affects how a microchip functions. For example, how much wire and electricity is needed for the chip to run. And so microchip designs have significant value to companies like Intel that make microchips. But it is a difficult process to make a microchip. It takes an interdisciplinary team of people months to make a new one. The team at Google says that the AI can make one by itself in under 6 hours. Not only that, but the chip performs better on all key performance indicators than a human-made chip. And so this is an AI that is automating something we traditionally think of as innovation. And a new design of a microchip is something that can get a patent. It's a little complicated, but generally that's the case. Now, this sort of phenomenon has not escaped the attention of policymakers, because when we have AI that can automate these useful activities, whether making images, inventing things, driving cars, or teaching classes, it is going to have significant economic and social impact. And so many countries around the world are launching industrial strategies for how they should best promote and regulate this sort of activity. And not just strategies and talking, some jurisdictions are coming up with new laws and regulations to make sure that the technology is used in socially beneficial ways. For example, the European Commission has recently published a set of laws specifically about artificial intelligence. These are not yet in force, but are likely to come into force in several years. They are not about intellectual property particularly, but they do completely prohibit some uses of artificial intelligence. And for other uses, they require someone to get an AI system approved, almost like a medical device, before it goes into commerce. And just as policymakers are looking at AI and regulators are looking at AI IP offices are looking at AI. In 2019, the US Patent and Trademark Office issued a public request for comments on the subject of AI and intellectual property, and they published a report in 2020. In 2020, the UK AI and IP office published a request for comments, and they published a report. And then they did a second one and published a report a few months ago. And they recommended some changes to the law, including a text and data mining exception that is somewhat similar to the one used in Japan and much broader than the one used in the European Union. They also recommended no change at present to their laws for AI making inventions and AI making creative works, which we will talk about shortly. These subjects are also important in international dialogues, including at the World Intellectual Property Organization, where the UN is trying to take a lead in having member states debate some of these issues. Because again, in a global intellectual property system, it is good to have a degree of harmonization. On the other hand, not every country is going to be leading in artificial intelligence. And so some jurisdictions may choose to have fewer protections for these sorts of things. But there are many ways in which artificial intelligence impacts intellectual property, copyright, patents, trademarks, because AI is now buying goods online and selling goods online. And this may change the nature of tests like trademark infringement and consumer confusion. There are videos being made of people who are deceased and taking place to reflect things that never happened, what we call deep fakes. And these have many issues related to intellectual property as well as privacy and ethics. So there's a whole range of issues related to AI and IP. In some sense, as I mentioned at the beginning, these issues are not so new. So this is a picture of a Soviet mainframe from the 1950s that Soviet researchers said was making music. And this music was really very bad. But what has changed is even if the underlying technologies themselves have not changed so much, although many of them have, AI has gotten a lot more capable and the adoption has increased greatly. So OpenAI, which owns the DALL-E 2 text-to-image generator that is now very popular on the internet, can also have their AI make music in someone's style. And this, again, is not yet good enough to be commercially relevant, but is almost at the level where an AI makes music that people will pay to listen to, including music that sounds like it was made by a popular star. And that raises interesting questions related to whether you can protect someone's style as a musician and so forth. This has become important enough that Equity UK, which is a union for performers in England, has launched a campaign to stop AI from stealing the show. And they are concerned that music and movie studios will take the likeness and style of human actors, have AI make creative works, and not adequately reimburse the human actors. This similarly is a piece of artwork from the 1980s that was supposedly made at least in part by AI. And now this sort of work is being sold for lots of money. So this was a piece that sold at auction in 2018, and it sold for about $500,000. You know, today there are dozens of tools being used to make art online, and they are selling for very significant amounts of money, including because many NFTs, which are cryptocurrency-based assets, are generated by artificial intelligence. And so there is really a market now for AI-generated art, but also a lot of uncertainty. You know, the law here is different by jurisdiction. I mentioned the United Kingdom has protected these works, and they have done that since 1988. They have a rule that if a computer makes something that can get copyright without a human author, the producer of the work is fictionalized to be the author, and there is a shortened term of protection. By contrast, the United States, since 1973, has not allowed these works to have copyright protection. And they base that on language from Supreme Court cases, including this case involving a very famous photograph of the author Oscar Wilde, which says that creativity is a human mental phenomenon. I'm spending a while talking about copyright for a couple of reasons. You know, one is because it is much easier to make something that is protected by copyright than something that is protected by patent. And so machines are further forward in terms of making creative works than they are in making inventive works. And so the law here is a bit more developed, and I think interesting and analogous, both for us to see how the technology will evolve and how the law may evolve. But in the United States, there has never, ever been a lawsuit until very recently about whether you could copyright a work made by an artificial intelligence. The policy of not protecting it comes from the US Copyright Office. And the only case that almost challenged it was this case involving a monkey taking a picture of itself, and it raised the question of whether something other than a human being could be an author. And ultimately, the case was dismissed, but not based on the policy, based on a court saying that a monkey could not bring a lawsuit. However, under US law, companies can be authors, and that has been the case for over 100 years. My research group recently filed the first lawsuit seeking copyright protection for an AI-generated image, which you see here. And although the AI is listed as the author because there was no human author, that does not mean that an AI would have any legal rights or duties. In point of fact, in US law, authors may have no rights or duties because authors do not necessarily own their own copyright. For example, when an author makes a work as an employee, the copyright in that work generally belongs to the employer, not to the author. In fact, in the United States, a company that has an employee author something can even list that it is an author. And so this lawsuit argues that this work should receive copyright protection because copyright protection, at least in America, is mainly based on protecting the public interest rather than protecting authors directly. And by allowing these works to have copyright protection, you will encourage people to make and use machines that make more works and to disseminate those works. And the net result will be that people have more creative works, which is the point of the copyright system. And again, the AI would not own this work, but the owner of the AI should own the work, similar to how an employer owns a work made by an employee. And that is reflected in common law rules of property ownership. So we will see what happens with this case. But now that you've seen a little bit about what's happening with copyright, I'd like to turn more to patent law and tell you about this case study from Siemens. Siemens is a large industrial company based in Germany. And the green component you see here is a car suspension. And the silver component that you see is a car suspension designed by an AI. And Siemens wanted to file for a patent on the silver component, but found that they were unable to because all of the engineers involved in the project said that they had not done anything involving inventive skill. They said the problem of developing a better car suspension was well known. The fitness criteria for a better car suspension was well known. They fed publicly available data to an AI that could optimize industrial components, and it churned out a design that was obviously valuable. And so the human beings involved in the project felt that it would be inappropriate for any of them to list themselves as inventors. And in some jurisdictions, that matters less, but in some jurisdictions, like the United States, having the wrong inventors on a patent can make a patent invalid or unenforceable. And deliberately, inaccurately listing yourself as an inventor can subject you to criminal penalties in the United States. So it is an issue with more importance in the United States than in places like Germany. But even so, Siemens felt that they were unable to file for a patent on this new invention. And so, as with the copyright issue, the real commercial challenge with having an AI automate invention is that, depending on the jurisdiction, you may not be able to get a patent. Now, of course, people use artificial intelligence in the inventive process all of the time, or a lot of the time. And that doesn't necessarily mean that an AI is an inventor. This is not dissimilar, though, from having many people work on an invention, and depending on the law of a jurisdiction, only some of them will be inventors. The law varies pretty significantly across different jurisdictions on who is an inventor and when. For example, the US takes a claim-by-claim approach to inventorship, and the United Kingdom takes a holistic view of inventorship. And so the inventors you list on a US patent and a EPO or a UK patent are often different people. Some jurisdictions, like Austria and Israel, do not require inventors to be listed on patents at all. And other jurisdictions, like Cyprus and Monaco, which are EPO member states, do not require that inventors be natural persons. But in any case, with an AI involved, there are still many ways that a human being could be an inventor. Sometimes, perhaps, by finding a problem to be solved, but not usually. Usually, we know what our problems are, like we would like a better car suspension. The trouble is finding a solution. Someone might also be an inventor by virtue of how they program an artificial intelligence. So if someone builds an AI just to optimize a car suspension, that might make them an inventor for a new car suspension. But it may also be that the people using the AI and the people programming the AI are different. The programmer may be dozens or hundreds of people spread over time and space. And while today we only have artificial intelligence that is narrow and can do a task, some tasks are broader than others. So you may have a pre-trained AI model that can optimize a range of industrial components, and you might not, as a programmer, even know specifically what components that AI will be used to optimize. At least in the United States and the United Kingdom, if you do not know the entirety of a claim, you could not purport to be an inventor of that patent. Finally, someone can also be an inventor by recognizing the value of AI output. For example, if an AI says, I have designed 10 new car suspensions, you should go test them and find the best one. The human being who tests those car suspensions and selects the best option is probably an inventor. But if the AI says, I have designed 1 billion car suspensions and I have modeled all of them, and this one here is clearly the best performing one, and here is all the data needed to file a patent application, then there is not necessarily anyone involved in the AI that has done anything involving any inventive skill. And thus, you may have an invention without a traditional human inventor. Now, I have been working on this issue academically for years, first because it was interesting, and then because some companies thought that it was an important issue for them to resolve, particularly companies doing drug discovery and repurposing, and companies doing materials engineering, where there is a lot of machines doing parametric optimization, for lack of a better term. The companies wanted to know how to handle these sorts of things, and that is something we can talk about more in our Q&A session. But also, it was very unclear how the law would handle this sort of thing because there were no cases on it anywhere. And so I led a group of patent attorneys in filing 2 patent applications for inventions made by an AI in the absence of a traditional human inventor. And this is our PCT filing you can see here. The applicant is listed as Dr. Stephen Thaler, who owns the robot in question. The inventor is listed as Dabis. The invention was autonomously generated by an artificial intelligence. Now, the reason we did that was that Dr. Thaler did not qualify as an inventor in our view under US law, and there was no human being who was an inventor. And the machine was factually the entity that invented this subject matter. Now, again, as with authorship, being an inventor does not necessarily involve rights and obligations. In some jurisdictions, it does. But in other jurisdictions like the United States and in the United Kingdom, inventors may never have any property ownership in their invention. Under most employment agreements where invention is likely to be an issue, inventions are pre-assigned to employers. And so the owner or the employee of an inventor is the applicant on a patent. In fact, most international patents are owned not by human beings, but by artificial persons in the form largely of corporations. And so, like here, our argument is that the owner of the AI owns these patent applications. There is no statute that dictates that, but there are common law rules of property ownership. For example, if I own a 3D printer that makes me a physical beverage container, I own that beverage container. No one would question that. And that is a property of a rule of law we call accession, which refers to owning property made by property. So if a 3D printer can make me a piece of tangible property, there's no reason that an artificial intelligence cannot make me intangible property or intellectual property, and that I should be able to own that. In July last year, South Africa granted us a patent with Dabis listed as the inventor and with Dr. Thaler listed as the AI's owner. Now, South Africa does not do substantive examination, but these applications already pass substantive examination in a preliminary examination by the UK IPO. And South Africa does do formalities examinations, and everywhere the application has been rejected, it had been rejected on a formalities basis. 3 days later, Justice Beach in the Federal Court of Australia ruled that an AI could be an inventor under the Australian Patent Act, and that at least in our case, the owner of the AI had the clearest claim of entitlement to the invention. Now, that judgment was overturned a few months ago by a panel of 5 judges of the Federal Court of Australia, and we are appealing it now to the Australian High Court. I appeared before the Court of Appeal in the United Kingdom, and there was a split decision. Justice Burse thought that we should receive a patent. Justice Arnold and Lady Justice Lang thought that we should not. But this case has very recently been accepted for an appeal by the UK Supreme Court. And so the UK Supreme Court, which takes a very small number of cases, is going to hear our appeal, though we do not yet have a hearing schedule for it. The US Federal Court of Appeals, or the Court of Appeals for the Federal Circuit, recently issued a decision holding that under US patent law, because the US Patent Act says that an inventor has to be an individual, it has to be a natural person. That's something we disagreed with and suggested that also a company could be an inventor under US law. And we are currently appealing that decision within the Federal Circuit. After that, it could be appealed to the US Supreme Court, although they take a very small number of cases. The European Patent Office recently heard our appeal, and they issued a decision that said, an inventor has to be a natural person. However, under European law, a human being could be an inventor by virtue of owning a machine that makes an invention. And you can specify in the specification of a patent that a person is an inventor by virtue of owning a machine. And so our applications were denied, but have been re-pursued as divisional applications. And we are now designating the owner of the machine as the inventor on the basis that he owns an inventive machine. This is similar to a decision reached by a court in Germany, where the intermediate court said, we do not have US or UK-like rules on inventorship. We only require that you list the person with the closest nexus to the invention. And if you wish to specify that something was invented by a machine to fulfill your obligations of transparency, you are entitled to do so. The German Patent Office is appealing this now to the German Supreme Court. So that is a bit about machine inventorship and about these legal test cases we are doing internationally. And I'm happy to take questions on them. I thought it might be interesting to mention, though, that really this issue of AI stepping into the shoes of people and being inventive, or even augmenting and making human inventors better, is going to be very disruptive. Because right now, to decide if someone should get a patent, we ask essentially whether an average researcher would find their invention obvious. But average researchers today are often using artificial intelligence. And so it makes average researchers more knowledgeable and more sophisticated, and thus it makes it harder to get a patent because more is obvious to a person using an AI than to a person not using an AI. If you think about some areas in which this may be very disruptive, you can think about in biotechnology, designing monoclonal antibodies. And these are what drugs are made of that are biological drugs. All of the best-selling biological drugs are monoclonal antibodies. And they are like antibodies made by your body to fight various pathogens. except they are all the same antibody made externally. And one of the interesting things about antibodies from an AI perspective is that there is a finite number of them possible. They are strings of amino acids, but there are only so many ways that you can string amino acids together. And so even though there's a very large number, more than trillions, there are not so many antibodies that an AI could not, perhaps soon in the future, sequence every possible antibody and publish that online. And machines can also model binding affinities for antibodies with known targets and receptors and propose formulations for new antibodies. And so it is not too hard to imagine that someone could have an AI that sequences every possible antibody, how to make them into a drug, and what that drug would likely do, and publish that all online. And if it did that, that might keep someone from getting their own patent on an antibody because it would be prior art. And a patent on a monoclonal antibody is the foundational patent of really all of the patent portfolios for biological drugs. And if that seems a little far-fetched, DeepMind, for example, is having one of their AI systems predict the shape of every protein in the human body and pretty much all the proteins we now know exist. So an AI cannot yet do that, but AIs are picking up bits and pieces of this as they move along. If you believe in this theory in computer science that machines are going to keep getting better and better, and when they start improving their own programming, they are going to become super intelligent and solve all of our problems, well, that is going to be tremendously disruptive for all sorts of reasons. But for those of us who take an interest in patent law, everything will be obvious to a super intelligent artificial intelligence. And so super intelligent artificial intelligence would make it impossible to get patents. Although that will probably be the last issue on anyone's mind if we have super intelligent machines. I will just kind of briefly re-allude to the fact that it is not just patents where AI performing like a person is going to disrupt our legal rules and standards. And it is not even just intellectual property. It is many areas of the law, including the difference in tax treatment behind how I am paid by my university and how an AI would be paid for by my university, and the fact that they pay taxes to employ human beings, but not machines. Or we now in San Francisco have commercially available driverless cars available that you can order on an app. And there are very different liability rules that apply to machines causing accidents versus people causing accidents. And so this phenomenon of AI behaving like a person is really going to be very disruptive to the law. For those of you who may be interested, I wrote a book recently on this. It was translated into Chinese, which was exciting for me. But then I saw that The Reasonable Robot, Artificial Intelligence and the Law by Ryan Abbott had become Rational Robots, The Future of Rule of Law and Artificial Intelligence by Ryan Albert. And I was concerned about this, including because I worried that the inside of the book might not make any sense. But on closer inspection, it turned out that a human translator perfectly translated it into Chinese, and that my browser's artificial intelligence was instantly and imperfectly translating it back from Chinese into English. So we don't need to quit our job as patent attorneys anytime soon. But the AI is doing its best to march in that direction. And on that note, I will stop and would love to take any questions anyone has.
Thank you so much for the informative presentation. I don't see any question from the audience, but yeah, for me, I like to know. So I understand drug companies have been using AI technologies to, make new drugs. So I wonder how many of them are actually, employing AI technology to already commercialize new drugs. Do you have any data or any guess at all?
Sure, I have some thoughts on it, although I do work for some companies like this, so I don't want to mention their names. But of course, it is a little bit challenging because if a company is really very concerned about this, they may not want to talk about it because they may worry it will have some impact on their IP. And particularly in drug development, IP is really very critical. Prior to these legal test cases, some leading startups in this space used to post on the front of their website, "Our AI invents new drugs." And, they have all stopped saying that. Now, whether that is really true is a whole different issue. Depending, I think, very much on a factual analysis of who does what when in this process. There is no company I know of that totally hands all of this over to an AI and the people really do very little. What the AI does is very context and situation dependent. And so there is very often, a good claim that a person is involved. But, not talking about it is probably not the right strategy either, because, I can speak more to how this would work in the US and the UK, but in the United States, when you sue someone for patent infringement, it is very commonly a strategy by defendants to query inventorship. Because if the inventorship is not right, sometimes the patent can be knocked out. And so, as a practical matter, if you list an inventor on a patent in the filing, no one is going to question it. But in discovery, in a deposition, if you ask the human inventor, like the Siemens engineer, "Oh, so tell me how you invented this," and she says, "Well, I didn't really have much to do with it. This came out of an AI and I didn't totally understand it, but we wanted to file for a patent on it. And the patent attorney said I should just list myself." That would be a real problem for your enforceability of your patent. So, the better strategy is to do a few different things. But if you want to be sure that you have a human being, you could make an inventor, that you design your R&D process to make sure you have someone you could point to clearly who is making some creative decisions. And that may increasingly be a problem as AI gets better, and having a person involved may slow some of that down. But many of the big drug companies have just in the past couple of years made significant investments in developing their in-house capabilities like this, or launched partnerships with some of the disruptive companies who really focus on this area. But I think there is a real sense right now in the biotech area that even if these technologies are not yet mature, that this is going to be the future of how drugs are made. It has a lot of potential to cut down on development costs also.
Okay. Thank you so much, Professor Abbott. I don't see any more questions here, so I think we need to wrap this up and end the webinar now. So we have the second poll. I guess relaunch poll. Okay. And we like to hear once again about this same questions.
Hopefully, at least everyone has now attended a lecture about AI inventorship.
Let's hear what audience say. There is one question from Mr. Okada.
So I can maybe summarize this question.
Yeah, please.
You know, the comment was it is not easy to get patent based only on hypothetical, virtual, or in silico examples. Most of the time, we need physical experiments to prove the invention will actually have an effect. Do I think this will change? Will we have higher expectations of success? The question is, oh, there we go. Higher expectations of success, you know, than we currently have based only on virtual examples. I think if we need wet experiments, that we will have a human invention. So that is a good point. It really raises several questions. For me, let's say that we really do need some experiment to file a patent. We want to make sure that we have, you know, a physical effect to support an application. That is not always needed, but as you say, it is certainly a best practice. Just doing an experiment does not make someone an inventor. So if, at least under US law, if I design an experiment for someone to do, and they just do the experiment and give me the results, that does not make them an inventor. In US law, someone has to have conceived of the invention, which involves either designing the trial or doing something in the trial involving inventive skill, like noticing the results aren't expected and changing the experiment or recognizing the value of it. So, you know, AI can and does design trials and experiments, which are frankly often fairly routine in this field. So I don't think that just because someone in the physical world has to do something necessarily makes them an inventor. But I think that there is some real tension between AI inventing things and AI becoming a routine means of generating output in a space, or for 112, as we'd say in the US reasons, you know, reducing undue experimentation. And so to me, when it becomes standard that everyone in a field, when they want a new antibody, just asks an AI and it says, here's your antibody, that sort of activity ceases to become inventive. As long as that is not the standard, though, then that activity should be inventive, in my view. But I think it very much depends on the facts of a particular case. Well, nice to see that the crowd is now evenly mixed between yes or no on AI inventorship. So, you know, even if this is not a space that you work in directly, I think it has lots of interesting implications for areas that we do work with. And I hope that this has caused you to think a little differently about it and maybe ask some more questions in the work you do. And Kamiko, are you there?
Thank you so much, everyone, for listening to this webinar. If you have any question about today's webinar or IACT services, please send those questions to info@iactokyo.com. We appreciate your feedback in the post-webinar questionnaire. Thank you so much, Professor, not robot, Professor Ryan Abbott. Thank you so much. Please stay safe and healthy. We hope to see you in the future webinar. Thank you very much.